There is no formula or way of calculating who pays attorney's fees in divorce cases. The courts have a simple formula in Florida and elsewhere. They try to create a level playing field. What does that mean? That means is if you have a family where one spouse is bringing in all the money and all the spouse is staying home and taking care of the kids and taking care of the household and doing the other things a stay-at-home spouse does, then the courts want to create a level playing field in terms of the parties' ability to obtain legal counsel. Now that doesn't mean that they both get to hire people who charge the same hourly rate or of the same abilities. What it does mean is the court's going to look at the circumstances of the case and try to determine what kinds of monies might be appropriate given the complexity of the case, the issues in the case, and how the parties are getting along. So how do they go about doing it? The next step in that process is the formula of, and here I go, I said no formula, but here it is, need versus ability to pay. In our example of one spouse earning all the money and the other spouse staying at home, we have a situation where one spouse has a great ability to obtain legal talent because he or she has income coming in on a regular basis, but the other spouse has no income and therefore no ability. Well, this again is where creativity and experience comes into play. There are ways to make the playing field appear to be level or to level it without hamstringing you as a breadwinner or hamstringing either person in the relationship in terms of payment of attorney's fees. What are some of those? You look to the non-marital holdings of the parties. Do they have any assets that may be considered non-marital? In Florida and in other equitable distribution states, that might be an inheritance. It may be a gift from a third party, an uncle, an aunt. Let's say there's $100,000 in an account. Well, if the non-working spouse has $100,000 available to spend on attorney's fees, then an argument could be made there may be no initial need for the payment of attorney's fees from one spouse to the other. All right? What's another one? Another one is a balancing of the incomes and assets. At the end of the case, the courts are going to try to balance the assets and liabilities of the parties. If, in fact, after the payment of alimony by the income-producing spouse, and after the payment of child support if there are children by the income-supporting, and after the payment of child support by the income-producing spouse, you may find that the actual incomes of the relative spouses now become somewhat more balanced. And if you have balanced assets and liabilities and somewhat balanced incomes, the courts may say no award of attorney's fees. So what do you do here? You look at creativity to try to explore all the exceptions that may occur in terms of not being the person who ends up paying attorney's fees. Remember, you only get divorced once in your life, and so it's important that you either consult with or retain the services of an experienced, board-certified family and marital attorney.